We continue with our coverage of the developments from the trial of the 5 men accused of murdering Orlando Pirates and Bafana Bafana captain Meyiwa. Today, his close friend Tumelo Madlala has identified in court accused number 2 from the 5 as the man he says had been pinned against the wall on that night by Meyiwa. Suspect, by the way, accused number 2's name is Bongani Ntanzi. There was a bit of back and forth among the legal representatives about whether it was proper for that to happen today. Let's take that up with Geri, Erasmus, Associate Attorney with Ulrich, Roux and Associates. Geri, a very good afternoon to you. Thank you for your time and your patience. Outside of the traditional identity parade, under what circumstances is it proper for a person to be identified by the witness during cross-examination or while on the stand, as happened today in court?
Good day, Timbukile. Thank you for having me. As your colleague said, a doc identification is very normal in a criminal trial, and the purpose is for the state to link and illustrate to the court that the accused that is pointed out is the accused, or in this case the intruder, that the witness, Madlala, has been testifying about during the course of his 3-day testimony. So it's not unusual, besides an identity parade, to in fact have identification done in a courtroom.
But there was disagreement among the legal reps about whether sufficient or appropriate grounds had been made by the state to allow for that to proceed. When would it be appropriate and when would it be not?
So in the normal circumstances, it is normal. It is permissible to do so. And you must remember that the defense attorneys and defense advocates always have an opportunity to cross-examine the witness on their identification. So our understanding is that an identity parade did take place, and the witness did attend only one identity parade and did not point out any accused, or in this case the second accused, who has since been identified. But it carries very little evidentiary value if you do not point out somebody in an identity parade and only do so in the dock. But it is permissible. So the defense's argument that there was no basis for this line of questioning is questionable, right, because it is permissible to do so. And
just on evidentiary value, let's talk about that. Does the identification today of Bongani Ntanzi as having been the man who, quote unquote, was involved in that scuffle with Meyiwa, so to speak, does that mean he's now legally in more trouble than his 4 co-accused?
No, it wouldn't necessarily render him in more legal trouble than his co-accused. And the reason for that is that, you need to consider the witnesses at the time that this offense happened, whether the lighting was good. The fact that the accused is said to have had dreadlocks at the time. It was a moving scene. So while he was moving with the dreadlocks in his face, was the witness able to, in fact, identify him? He was also known to be drinking during this time. And, that the fact that he may have been intoxicated would possibly raise questions as to whether he could identify the intruder and identify the accused number 2 as in fact being present at the scene. Whether this testimony is requested or rather said to be credible will lay with the judge. It might be credible, but whether it's reliable is an entirely different question. Again, I mentioned the factors such as lighting, the time of the offense, the people in the house had been drinking at the time. So it's that credibility versus reliability of the evidence, but it wouldn't render him in more legal problems as such, because your defense then have the opportunity to cross-examine the witness.
To your point about, pardon me, Geri, to your point about the drinking, in fact, Advocate Tobani tried to establish later, once they appear to have moved on from that, how much liquor had been bought on the night. Would that, do you think, also tie in, perhaps later when he wraps up, with proving that they may have perhaps consumed so much alcohol that anything they say about spotting a stranger could not be taken as credible.
Definitely, and it may be credible in the sense that the witness feels that his testimony is credible, but it may not be reliable, because if they had consumed a large quantity of alcohol in the evening, that would definitely play a part in whether you are accurately able to identify a stranger or an intruder that has come into your house. Also, just on a separate note, a firearm was produced, and the minute a firearm is produced, you sort of go into the survival mode where your focus is now turned to a firearm and whether you need to protect yourself, and you don't necessarily zone in on who the intruder is and take note of their features during that time.
A quick final one. The issue of the statement and statements, because Madlala says he was questioned several times, and in some of those cases he wasn't even aware that he was giving a statement. He thought he was just perhaps clearing out issues as per the questions of a member of the SAPS. Once a person has signed a statement, how much weight does that carry? Your signature, does it fully commit you to the contents of the statement?
It would, because you are deposing to an affidavit, and when you depose to an affidavit, you are saying that the facts that are placed in this affidavit are in fact true and correct and to the best of your knowledge. However, you might, as time goes on, you might remember different things throughout the couple of months that take you back, and you may add on or supplement your affidavits or your statements, but it carries a lot of weight when you do depose to a statement. You can't simply keep changing your version. That would be looked upon in quite a bad light by Judge Marmela.
Geri, Erasmus, good to speak to you, Associate Attorney with Ulrich, Roux and Associates.